I just saw on news last week some lawyer was just like blasted from the bench because he put something up there and it made up stuff. And I mean, he had his law license threatened, and he was able to come through it. But man, it was really touch and go. And his client was just absolutely livid. He looked like a monkey. So answer that objection?
Yeah, I always kind of start with, as lawyers, our duty to sign that the pleadings or our filings are true and veracious and grounded in law and in fact to the best of our knowledge. That hasn't changed just because AI came into the picture, right? We still have to do that, right? So that's what blows my mind with some of these hallucination cases. You still do have to read and verify. If you're putting a brief before a court, you still do have to read it. Supio would never suggest that you should completely abandon reading and independently verifying your own filings. That's a quick way to lose your license. So it's interesting because the courts keep coming out with more and more opinions. More and more circuits are starting to weigh in. And what I am noticing as the trend is that courts are not saying don't use AI. They're saying if you don't use it responsibly, we will come for your license. And certain types of communications with your AI are not privileged, can be um, can be producible and discoverable. So it's interesting, and if we talked in a month, Zane, it would potentially be a different conversation on this front.
So what does Angela? So what does blah 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 implementation actually look like? What does the firm have to stop? Does the firm have to stop taking cases for a month to get this set up? How complicated is it to implement it?
Absolutely not. No, please don't stop taking cases. That's the bread and butter in some of the firms. In the smaller firms I work with, it's truly chicken for dinner one night and feathers the next on a PI model because they're billing contingently, not hourly. So the implementation piece, it really is customizable to the firm. We have firms that are very AI savvy that have already been prompting wizards in Chat GPT, and we don't need to focus on the prompting piece, right? We just need to focus on here's how you get cases into Supio, and here are some of the things that you can do with it. Go nuts and configure it to your goals, right? And then we have the more, I don't even know how to prompt. I don't know what Chat GPT is. I'm scared of AI. And then we kind of start from square one. Okay, here's how you want to prompt. So it really does depend, but the short answer is we have a onboarding team, a customer success team that is there to provide as many trainings as are needed. As new staff come in, we will train them. As new features are released, we'll train the staff on those new features. So we really want to make sure that it's not just implementation, that it's true adoption across the firm.
So what happens to a firm's client data? Does it ever get used to train the model?
No. So Supio is entirely SOC 2 and HIPAA compliant. We also are GDPR compliant, and your client's data stays closed within your client's case. We do not use any of your client's information to train our model. And so also your firm's data is siloed within your firm, and your personal chats with Supio are siloed within your individual membership in Supio. So if you're a paralegal and you're asking Supio to help you draft a memo for the managing partner is not going to be able to see exactly what your chats within Supio are, but they will be able to see the final output that you hand to them.